Good morning, everyone. Thank you for joining us for today's Knowledge Bank, which is being presented by Jonathan Wragg from PDC Law. He is going to be speaking to you about the Freehold and Leasehold Reform Act, in particular the service charge changes and what they could mean for you. If you have any questions throughout the webinar, then please submit them in the Q&A box at the bottom of your screen, and we will try to get through as many as possible at the end. The webinar is also being recorded, so it will be available to watch back on the News on the Block YouTube channel. That is all from me, and I'm now going to hand you over to Jonathan to begin.
Thank you very much, Vicky. Good morning, everyone. My name is Jonathan Wragg. I'm a Director of Law here at PDC Law, and I'm also a barrister practicing from Highgate Chambers. Just the tiniest of plugs, both PDC Law and Highgate Chambers specialise solely in the recovery of property-related debts, and that's work I've been doing for some 15 years. Well, thank you for joining us for this News on the Block Knowledge Bank webinar. The title of the talk is the Leasehold and Freehold Reform Act 2024, and the subtitle is Service Charge Changes, What They Could Mean for You. Just 3 health warnings before we start. The first is that the bits of the Act that we're going to speak about today haven't been brought into force yet. Now, there is some confusion among my friends as to what that exactly means, because they will have heard that there was the wash-up period in Parliament and this Act squeezed through at the last minute. That is all true. The Act is now on the statute book. It's received royal assent. But with all legislation, there has to be a commencement date for individual sections in the Act. And this Act has not yet been brought into force. There's a tiny bit that's been brought into force, but that's not really relevant to what we're talking about. So everything I'm talking about today is prospective, and it will depend on whether or not a commencement order is made, and obviously the date of that commencement order. So not in force yet. We expect it to come into force. When it'll come into force, we don't know. Second health warning is I'm not talking about the whole Act this morning. It's really focusing on service charges, a little bit about administration charges, small bit about ground rent. But the focus really is about service charges and debt recovery, and I don't, for example, stray into areas regarding enfranchisement. The third bit of the third health warning is in respect of the fact that the Act is very much in skeletal form. So what you'll find is there are many references in the Act to regulations being made. Obviously, these regulations haven't been made yet because the provisions of the Act are not yet enforced. So very much, all the detail essentially is going to be set out in regulations. So what you have is an Act giving a broad overview of what's going to change. But in this case, the devil really will be in the detail. So I will be saying, well, this part of the Act says X, Y, and Z, but regulations need to be brought in to sort of put meat on the bones. Okay, so before I start my talk, I thought I'd give you a brief quote from Arnold and Britton, which was a case in the Supreme Court. And I wonder what we'll make of this quote when we come towards the end of the talk. The quote I want to rely on is a quote of Lord Newberger, and he said, legislation which started to come into force in 1972 has rendered it progressively more difficult for an amateur landlord to recover a disputed service charge debt. My thought at the start of this talk was, well, the Supreme Court has acknowledged that essentially there's so many protections for tenants that it's almost impossible for an amateur landlord to recover disputed debt. And what will this Act mean if it comes into force? What will be the impact on this Act on particularly amateur landlords in trying to recover charges? What I have in mind there is that the government seems to be suggesting that more and more amateur landlords or leasehold owner landlords become more and more involved in service charges. I just wonder whether or not they thought through what the implications of this legislation would mean for those landlords who are owned by leaseholders who may, not necessarily, but may be doing this themselves. Okay, so the first thing I want to discuss was the extension of the service charge regime to fixed service charges. So as most of you will know, currently the 1985 Act, that's the Landlord and Tenant Act 1985, applies only to variable service charges. So all the familiar concepts that you're used to dealing with in terms of reasonableness, consultation requirements, apply only to variable service charges. The Act will radically change that if and when the relevant parts come into force. Incidentally, when I put square brackets, those are the relevant sections in the Act if you wish to cross-refer them later. So extension of service charge regime to fixed service charges is covered by section 53 of the Act. And what that will do is give those subject to a fixed service charge the same protections as are afforded those who only have to pay variable service charges. So the concepts of reasonableness, the consultation requirements, grant-aided works, and the 18-month time limit, and also the protection in respect of building safety works, will also now to apply to those paying fixed service charges. That is a big change. The Act and its predecessors, since inception, has only applied to variable service charges. Now this Act would fundamentally change that. The second item to talk about is notice of future service charge demands. And this is set out in section 54 of the Act. Currently, if a landlord is going to require a tenant to pay for service charges at some point in the future, they have to serve a notice under section 20, and that notice have to tell tenants that their costs have been incurred and they will subsequently be required to contribute towards them. That requirement will now be abolished. It's a little bit cumbersome and it's been subject to a lot of case law. So in future now, the landlord will be required to serve a future demand notice. And that notice must be in the prescribed form and it must contain specified information. Now, as I said earlier, much of the detail is missing from the Act. So this is one of those occasions where precisely what the future demand notice will look like, and what form it will take, and what information it will contain is set out in regulations. And if you're in the mood this morning and you want to play a little game, you can count out the number of times I'm going to say that the details will be set out in regulations. So that's a first occurrence, and we'll keep a running tally as we go along. The second item is service charge demands. That's set out in section 55 of the Act. Again, this is a big departure. Currently, there is no form of prescribed service charge demand. That's to be contrasted with ground rent, where there is a prescribed form of demand. But now, if it's brought into force, there will be a prescribed form of service charge demand. And accordingly, the following sections of the 1985 Act will be repealed. So that's sections 21, where a tenant can request a summary of relevant costs. Section 21A, and that's the ability of tenants to withhold service charges. And section 21B, the notice to accompany service charge demands. So all the current provisions would be repealed, and you would have a new prescribed form of demand. Excuse me. So in some ways, it's easier because everything is prescribed for you. but in some ways it will be a little more difficult. Currently, in respect of ground rent cases, for example, there are always instances where tenants suggest that the ground rent demands don't quite follow the prescribed form, and there's usually going to be lots of arguments or how much of a discrepancy is sufficient to invalidate a demand. Does it have to follow the prescribed form precisely, or do the courts have some leeway? In one case, I was dealing with a tenant alleged that a missing S from the prescribed form of words completely changed the meaning of the demand, and that they were completely misled as a result. In that case, the argument didn't really succeed, as the tenant had alleged they hadn't received the demand at all. So how they could have been misled is a matter for conjecture. But the point is, there will inevitably be some instances where demands don't quite follow prescribed form, and then there's probably going to be some legal arguments as to what the effect of that discrepancy is. So there we have it. There's going to be a new form of service charge demand. Next, there's going to be a requirement for accounts and reports. This is section 56. So as all of you know, currently what landlords have to do, and management companies and right to manage companies have to do, is follow the terms of the lease. There are generally no statutory requirements setting out a need to provide accounts and reports to tenants. Now there's going to be a requirement for both. Certainly, in the case of the statement of account, that's going to apply where there are 3 or more tenants. And this statement of account, it has to be certified by an accountant. The statement of account will need to be provided within 6 months of the end of the service charge year. And there's a new requirement for annual reports, and those will need to be provided within 1 month of the end of the service charge year. Now, I've had a look at section 56 a few times, and it's quite hard to determine what the difference is between the accounts and the reports. If some of you know, do please let me know in your comments. Certainly the requirement for the statement of account is sort of set out in a bit more detail in the Act, but in the case of the annual reports, again, the Act just says the detail is going to be set out in regulation. So in respect of section 56, the regulations are mentioned twice. So we really need to see more detail through regulations as to precisely what these requirements are going to be. There's going to be an overhaul on the right for tenants to obtain information on request. This is set out in section 57. Currently, these rights are split over a number of sections in the 1985 Act, sections 22 to 25. But if this proposal, well, it's not so much a proposal, but if this law is commenced, if there's commencement order, sections 22 to 25 of the 1985 Act will be repealed, and there will be a new right to make a request for information. If the landlord doesn't have the, I'm using landlord, by the way, as a shorthand. There may be other cases of parties that apply, such as management companies. So we're looking at the extended definition of landlord here. The landlord may be required to seek information from third parties. Costs can be charged for giving information or providing copies of documents. And there will be no enforcement methods for any landlords who don't comply with the information regime. So currently, their non-compliance with section 22 to 25 result in a criminal offence. But I'm not aware of, I don't think I'm aware of any cases where landlords have been prosecuted for not providing information. You know, I mean, I may be wrong, there may be cases out there, but it may well be that the police and local authorities think that this is perhaps not the most serious of offences, and not much effort seems to be put into commencing criminal proceedings against landlords. But now, to do away with that, the Act will say no longer a criminal offence, but tenants will be able to apply to the first tier property tribunal on various grounds. They'll be able to say that the demand that we talked about earlier was not demanded correctly. The report that we mentioned, they can say that that was not provided properly, and that information was not provided. So these new enforcement methods cover the bits we've been talking about so far in respect of prescribed form of demand, the reports and information provided. The tribunal could make various orders, including that the demand or report is made correctly, that the information is provided, and significantly that a landlord can pay damages in relation to non-compliance up to £5,000. So now I think this is Parliament acknowledging really that the criminal offence was not really much of a disincentive, as it happens so rarely. But what we're going to do now is punish landlords by ordering them to pay damages up to £5,000 in respect of what, frankly, in my view, could be minor breaches of requirements. So these are significant changes, and the ability to apply to the tribunal on various grounds for various reasons is extended. So we see a lot of that in the Act of tenants being able to apply to the tribunal if they have a grievance in respect of any matters. Of course, this is another example of regulations having to be made to specify the details on how landlords can be fined and how much they can be fined. So again, this is an example where regulations will need to show all the detail. Moving on to a new topic of insurance. So now there's going to be a limitation on insurance costs, and that's section 59 of the Act. Reading through the legal jargon, essentially, what the Act does essentially is to introduce the concept of an excluded insurance costs, and effectively that's commissions. So what the Act is going to say is that landlords cannot pass on to tenants effectively commissions. And instead, the Act will introduce the concept of a permitted insurance payment, again to be clarified in regulations. So now you can't pass on commissions, but you can have a permitted insurance payment. So the government say, this I think is more to do with transparency. I don't think it means that landlords won't be able to recover any money in respect of organised insurance. It's going to be more clear. It's not going to be a commission or just a commission. Now you're going to have a permitted insurance payment, which in my view is likely to be the same effect as a commission, but the legislation will set out exactly what landlords can claim. Again, tenants have the right to apply to a tribunal if an excluded insurance cost is charged, and again, the landlord could be ordered to pay damages in respect of excluded insurance costs. Now, that's important. Not only will you not be able to recover excluded insurance costs, if you do charge them, they're likely not to be payable, and also a landlord could be ordered to pay damages on top. On the plus side, there will be an implied term that a landlord can recover permitted insurance payments. Hand in hand with the new regime is a duty to provide information in respect of insurance costs. This is section 60 of the Act. I just have to repeat, none of this is enforced yet, but it's likely to be enforced, or a version of it is likely to be enforced. How long that will take, we don't know. Anything from 12 months to 24 months are the suggestions I've heard. But a landlord will have a duty to provide insurance-related information. And that duty extends to seeking information from third parties. And again, a tenant can make an application to tribunal if it says that the landlord hasn't complied with its duty to provide information in respect of insurance. So what is that information? We don't know at the moment. What information you're going to have to provide is very much up in the air because, again, it is subject to regulations. In fact, I think in respect of section 60, the Act mentions regulations 4 times. So by now, you're probably getting the message that the Act is very much skeletal in terms of what it's going to require from landlords. And the devil really will be in the detail. And we will need to see what the regulations actually provide. Right, moving on to a new topic in respect of administration charges. At the moment, the underlying theme of this Act, I think, is, well, certainly the way the government has sold it, is in providing more clarity of information for tenants. So it's been deemed that the regime in respect of administration charges is a little opaque, and that tenants, at least some of them, don't know what they may be required to pay. In practice, I'm not sure if that is true. The reminder letters I see are full of warnings of what a tenant might have to pay if more work is required. But in any event, now there will be a new duty requiring landlords to produce and publish administration charge schedules. The current requirement to serve notices with administration charge demands would be scrapped. A landlord would be required to provide each tenant with a copy of the schedule. How they're going to provide each copy of the tenant with a copy of the schedule isn't clarified. Again, there are 2 references to regulations being drafted. The important point here is that an administration charge not set out in the schedule would not be recoverable. I think it's important to point out here as well is what this won't do is give landlords or any of PDC Law's clients an ability to charge new administration charges that they couldn't currently charge. All this change of law will do is to say where you can charge an administration charge, you now have to publish a set schedule setting out what those charges are, and you have to serve a copy on the leaseholders. It doesn't mean that the administration charges will be reasonable necessarily because they set out in a charge schedule. It's just a freestanding obligation to publish and provide each tenant with a copy of the schedule. Again, the tenant could apply to a tribunal in respect of breaches of duty, and again, a landlord could be ordered to pay damages. And in respect of an administration charge schedule, these damages could be up to £1,000. There are 2 sets of regulations that could apply to administration charge schedules. A contentious aspect of what was the bill is the provision in respect of leasehold sales information requests. This is set out in section 67. This gives tenants the right to make a sales information request. And this applies where a tenant is thinking of selling their lease. The tenant can make a specified form of request. The request must contain specified information. The landlord must give information in his possession or seek information from third parties. A person giving a request, including those third parties, must provide a negative response confirmation if they do not hold the information requested. A person can make a charge in dealing with a request, which may be limited by regulations and will not be deemed to be an administration charge or a service charge. Again, we don't know precisely what information tenants will be able to request. Obviously, this will be to do with the sale of the property, and it's geared at tenants selling and what their buyers want to know, presumably what the average service charge is for the last couple of years. If there are any big ticket items coming up, I imagine they will be there. But again, they will be covered by legislation. Section 67 has 5 references to regulations being made. Again, this new stick that seems to have found favour with this government. If a request is not complied with, an application can be made to the tribunal, which could order compliance with the request, the repayment of charges made, or damages capped at £5,000. So that's sales information requests. I'm sorry for changing topics so often, but there's so much to this Act. I have an hour, so it does mean going through them quite quickly. So a completely different topic, new regulation of estate management. So essentially, under the current regime, estate rent charges, essentially freehold service charges, aren't covered by the 1985 Act. Subsequently, the FTT doesn't have jurisdiction over them. That will change if Section 72 of the new Act is brought into force. The Act will extend regulation to estate rent charges, essentially freehold service charges, and would include familiar protections. Again, I won't go through them all, but all the concepts they are used to in respect of variable service charges will now apply to estate rent charges. So you have a concept of reasonableness, consultation requirements, and application of dispensation, the 18-month time limit, and also the new items that we've been talking about today. So demands to be in a specified form, provision of annual reports, right to request information, and the ability to apply to the tribunal if a tenant alleges that there's been a breach of any of the requirements. The second column, there's the power of the tribunal to order compliance or the payment of damages, duty of estate managers to provide administration charges, and again, the tribunal could order the landlord to pay damages. There is halfway down the second column, there are the codes of management will be extended to estate charges. There could be a notice of complaint, a final warning notice, and the appointment of a substitute manager if complaint is not responded to. There would be various essentially false-based grounds on which a substitute manager could be appointed. Finally, provision is made in respect of sales information requests, so they would cover the new estate management regime as well. Hand in hand with the last item, there would be leasehold and estate management redress schemes. That's set out at section 100 of the Act. Landlords and estate managers could be required to be a member of a redress scheme, though this would not apply to tenants or agents. The scheme would provide for an independent person to resolve complaints, and there would be consequences of breaching regulations, and that would include the appointment of managers, and it could result in financial penalties. Again, there's various references to regulations being made. In respect of the enforcement of estate rent charges, these are currently set out in sections 121 and 122 of the Law of Property Act 1925. Again, there will be a wholesale change to the current regime. So these are, what we're talking about here is essentially the enforcement of estate rent charges, i.e. where freehold owners have an obligation to pay what are essentially service charges. They don't pay, so what remedies does a freehold owner have against its clients where they don't pay their charges? Now, if this Act goes through, there will be the introduction of the concept of the regulated rent charge. Now, a notice of arrears would need to be served, roughly equivalent to a service charge demand. The demand would have to contain prescribed information, and the demand must be accompanied by a copy of the rent charge. There are service provisions and again various powers required, enabling, I should say, the Secretary of State to make regulations in respect of the enforcement of estate rent charges. Again, I'm sorry that so much of this detail is lacking. It's just not there. Essentially, what I think this Act does is to say we want to introduce changes in various areas. It announces what areas are going to be made, and essentially then just says, okay, the Secretary of State may make regulations. So very much what the detail is going to be is what's going to matter. But unfortunately, we don't know what those details are at the moment. I said I wouldn't really deal with anything other than service charges, administration charges. This is one exception. So Section 48 of the Act does introduce a power to vary leases to replace rent with a peppercorn rent. You will be familiar, I suspect, with the Leasehold Reform Ground Rent Act 2022. That prohibits the creation of new leases that require the payment of ground rent of more than a peppercorn. The new Act, again, introduces the concept of current leases being amended so that no more than a peppercorn can be demanded. But again, the detail is not there. It's certainly not in force, and I imagine will be the subject to lots of regulations. Frankly, I've stopped counting as to how many regulations the government says can be introduced. But again, all this is going to be in the detail. There is provision in the Act to replace an obligation to pay ground rent in existing leases with an obligation to pay a peppercorn. For those of you who don't know, the obligation to pay a peppercorn is really a euphemism for saying that there will be no ground rent, because in practice nobody demands a peppercorn as rent. Importantly, there will be a limitation on rights of landlords to claim litigation costs from tenants if Section 62 of the Act is introduced. Currently, landlords enjoy, in many cases, a contractual right to recover costs from tenants. That will be largely scaled down if Section 62 comes into force. The current Section 20C would be repealed. There would be a general ban on a landlord's litigation costs being recoverable as a service charge. And in this case, there's an extended definition of landlord to anyone who can recover a service charge. But late amendments to the Act means there could be possible exceptions. So just to unpack that a little bit, currently landlords are entitled to claim litigation costs from tenants if they have a suitably worded clause in the lease. Quite often it's a clause in respect of preparing Section 156 notice, or less often there is an indemnity provision in the lease. And in those cases, the courts have held, the Court of Appeal has held, where there is a contractual right to costs, then courts really should give effect to that right. So there's a strong presumption that if your lease says that the landlord can recover costs for claiming service charges from you, i.e. having to go to court, then the court will give effect to that right. That presumption is now going to be overturned. There will no longer be a presumption that the provisions of the lease trump the court's powers. Instead, a landlord would have to apply to a tribunal or a court for an order for costs against a specified person. And rather than this being a contractual right, the court or tribunal could make an order if it considers it just and equitable in the circumstances. When deciding whether or not to make an order for costs, the court or tribunal would have to take into account any matters specified in regulations, and regulations may provide how an application is to be made. But the final part of that slide is that a landlord can only make an application for costs. One, if it satisfied the Court of Tribunal that it was just and equitable to make a charge, but only if it has an existing right to claim costs in the lease. Section 62 does not give landlords a freestanding right to claim costs in the county court or the tribunal. It's only if they have the current right, that current right has been curtailed. Instead of a presumption that they can now get costs, the landlord will just have to make an application and persuade the courts that it would be just and reasonable to make an order for costs against a defendant. Similar provision is made in respect of administration charges, and this is section 62. So now again, instead of a landlord saying, well, there's a provision in my lease which says that I can recover from the tenant by way of an administration charge the cost of commencing proceedings to recover service charges, instead of that, that obligation on the tenant is revoked. It's no longer of any effect. And a new provision would apply that no administration charges is payable by a tenant of a dwelling in respect of the landlord's litigation costs. But as in the case of service charges, which are litigation costs, a landlord could apply to court or a tribunal for an order against a specified person, and the tribunal could consider making an order if it's just equitable in the circumstances. So again, just trying to short circuit that, it is quite detailed. Now there's essentially it's more than a presumption. You're almost guaranteed to get your costs if the lease says you can claim your costs from the tenants. The Court of Appeal has given an effect to that in various decisions. If your lease says you can claim costs, you can. Now that provision, even though you've got a contractual right to it, is being scrapped. It's now going to question not whether you have a contractual right to your costs, but whether or not it's going to be just and equitable in all the circumstances. So that covers both service charges, i.e. putting legal costs through the service charge, or costs from an individual tenant, which is administration charges. Now, only if it's just and equitable to make an order against those tenants. The Act introduces a new right of tenants to claim litigation costs from landlords. So currently, I've probably dealt with probably 1,000 tribunal claims. I've never seen a clause which entitles a tenant to recover its litigation costs from landlords if it's been successful. But now the proposed act, if it comes, the proposed provision, if it comes into force, this is section 63, will give tenants a right to claim their costs from landlords if it's just an equitable in the circumstances. But it's not quite a level playing field, because in the case of the landlords, a landlord could only claim costs if it's already got a right to claim costs against tenants. In the case of tenants, they don't need to have a contractual right to claim costs against landlords. This is now a freestanding right of tenants. Whether the lease says that tenants can claim costs against their landlords or not, there will now be an implied term into a lease that if a tribunal or a court orders a landlord to pay costs against tenants, then the landlords will have to pay those costs. Once again, there is provision for regulations to be made. Finally, I just would like to mention some other legislation. There was the Leasehold Reform Forfeiture Bill introduced in the House of Lords on the 1st of December 2022. The bill was supposed to require landlords exercising a right of forfeiture or re-entry in relation to a property subject to a long lease to account to the tenant for that tenant's equity in the property. In other words, currently, where a landlord is able to forfeit a lease, it just takes the lease back from the tenant. What this 2022 bill proposed where a landlord forfeits a lease, all it can do is recover the money that it's owed and then pay back the tenant the remaining value of the lease. So say for example, a lease is worth £200,000. The service charges owing were £20,000. The landlord could forfeit the lease, i.e. get the lease back, sell it, retain his £20,000, but then pay back the tenant the £180,000 difference. That bill has never progressed, and I think it's very unlikely to do now because it's a private member's bill and most of those fail, and that seems likely to fail. There was some amendments moved to the Act in respect of forfeiture. Some had tried to ban the remedy of forfeiture in respect of service charges, but that never took off. It's not part of the final Act. Back to where we started. For those keeping track of the references to the regulations that are going to be made, I've counted 48 instances where the legislation says further detail will be set out in regulations. If there are 48 different sets of regulations, then you can well imagine that the regulations are going to be far longer than the Act itself. And what that means is an awful lot of work needs to be done before any of the provisions of this Act could come into force. One, that's likely to take a very long time in my view, and two, it's likely to give landlords an opportunity to have their say in respect of those regulations, because a lot of questions remain unanswered, it seems to me. The Act seems to be keen to cut down on the ability of landlords, for example, to recover litigation costs. But this goes back to the second point I was wanting to make in respect of the quoted law new, that it's almost impossible for amateur landlords to recover a disputed service charge. As far as I can see, if more and more tenants and leaseholders are going to be encouraged to manage their own buildings, then these problems, it seems to me, are going to get worse for these leaseholders. The current law in respect of service charges is quite difficult in my view. There's lots of legislation, there's lots of case law, there's guidance, there's risk code of conduct, lots of regulations. There's going to be a whole phalanx of more regulations added to the current body. And the idea that, with respect, nothing to the fact we're just amateur, but the idea of somebody dipping into this legislation and getting it all right, I think is quite far-fetched. And if you imagine you do have a lessee-owned, say, management company or a lessee-owned freeholder, they're essentially suing one another for service charges, yet as the Act currently stands, it seems very unlikely that, well, not very likely, but at least possible, that these landlords wouldn't be able to recover their service charge costs that relate to litigation. In those circumstances, I wonder how the framers of this Act think that this whole scheme is going to work. You have tenants who are not paying, their colleague leaseholders have commenced proceedings against them, but unable to recover their costs of doing so. It seems to me that perhaps there's not been a lot of joined up thinking. Right, thank you. That's the end of what I wanted to say. If you have any questions, then do please let me know, and I'd be delighted to try and answer them.
Hi, Jonathan. Thank you. We do have a few questions here already, so I will go through some.
Yes.
Okay, so the first one I think is from earlier on in the presentation. George was asking, is there any guidance around when the regulation is going to be published and become effective?
No, there isn't, and I think the main reason for that is there is going to be a change of, it's very likely to be a change of government. It's not certain, but although I think Labour have been broadly supportive of this Act, it's not clear what precedence they're going to give to it. I can well expect that a Labour government might want to push through its own legislative agenda. And it might think that service charges are important, but there's so much detail in these, I wouldn't be surprised if it's not the greatest priority and he wants to push through other legislation first. But from what I've heard, I think the minimum period I've heard is 6 months, and the maximum I've heard is 2 years. But don't forget, it's not just a question of the regulations coming into force. It's most of the act itself isn't in force yet. So before the regulations can be drafted, the act needs to be brought in as well. So between 6 months and 2 years is my best estimate.
Okay, thank you. Got another question here from Sarah. She's asking, in regards to section 61 and the reference to reappealing notices, is this referring to the summary of rights?
Sorry, just remind myself, 61 in relation to what, sorry?
In regards to section 61 and the reference to reappealing notices, I think this is about halfway through your presentation, she asked this question. Is this referring to the summary of rights? I don't know if you can elaborate any more on that, Sarah.
So section 61 was the duty of landlords to produce and publish administration charge schedules. So under the proposals, the current requirement to serve notices with administration charge amounts would be scrapped. So there would be no obligation to serve those administration charge notices, because they will be overcome by the schedule, which will have to be published and sent to tenants. So what tenants would have would be an obligation to the tribunal to bring landlords to account if they don't comply with the requirements. So if a tenant says, well, you haven't produced your schedule, you haven't published it, you haven't sent it to me, or you're trying to charge me sums that aren't in the schedule, then the tribunal can make various orders, including the landlord to pay damages. So if I've understood the question correctly, which is to do with notices, I don't think that would actually apply anymore, because there would be no requirement to serve any notices. Just the obligation to produce and publish a schedule. If they don't do that, the tenant could apply to the tribunal, and the tribunal can make various orders, including an order to pay for the landlord to pay damages up to £1,000. I hope that answers it.
Okay. Yeah, Sarah's not sent a follow-up, so if that doesn't answer the question, Sarah, you can get in touch with us and we'll try and give you some information after the presentation.
Yes.
Okay. Are there going to be forums where landlords, RTMs, RMCs, and leaseholders can make their views known?
That's a very, very good question. There are various bodies. I think there's a Freehold Landlords Association. Again, I don't want to give you any more work, Vicky, but I do think there's a case made for somebody to be sort of trying to channel this, because PDC Law gave evidence to the committee dealing with this act in respect of the smaller landlords. But there hasn't been much of a groundswell of landlords thinking, hang on, these changes are really significant. So at the moment, I'm not aware of any body that's particularly taking on a lobbying function, but there should be, because the changes are significant, and I don't think that most landlords and agents want to wait until these provisions come into force before thinking, hang on, the impact of these is really quite severe. So I imagine that when if any regulations come to be drafted, quite often they're put out for consultation. And in the absence of a body being established to sort of put forward landlords and RTM companies' rights, that the best opportunity would be to reply to the consultation with any concerns you have. And one of the biggest concerns I briefly touched on, is the fact that some landlords aren't going to be able to recover their legal costs of taking tenants to court for service charges. And if you're, a company made up of leaseholders, you're going to chase leaseholders who aren't paying and have to pay their legal costs. It sounds a little bit odd to me. I just can't believe it's been thought through. So short answer, no. Slightly longer answer is there should be, and if there isn't, then probably replying to consultation in respect of regulations is probably the best way.
Okay. I've got a question here from Tim. Given the requirement for an annual report within 1 month of the period end and certified accounts in 6 months, could this lead to a lot of erroneous and confusing information being provided to leaseholders should the certifying accounts propose adjustment?
Yes, well, I think even without the certified accounts proposal adjustments, there's a recipe for confusion. I open it up to anybody who's got a slightly better idea than I have, notwithstanding the numerous cases I've done in respect of service charges. I can't quite at the moment see what the difference between these accounts and reports are. But yes, to answer Tim's question, yeah, I can see there's going to be confusion if adjustments are proposed. You're talking about 2 different time periods covering slightly different things. And yeah, I think well said, it's going to be a recipe for confusion. I imagine you'll have to spend a lot of your time explaining why there are both accounts and reports and what the differences are between them.
I've got a question from Pat. Could you comment on the relationship between the value of leasehold property and the size of ground rent? She says that she has heard that above a certain value, the ratio affects the freeholder's powers.
Honestly, it's not too much I know about. I know there were proposals made to cap ground rent. So I think was it 0.25 or 0.5% of the capital value, but they have not been passed in the Act. Frankly, what I think happened is that I'm taking a non-party political stance here. But if I have a slightly cynical hat on, I would say that the Tory government were quite keen, seen to be doing a lot of things in respect of service charges. But I think the detail became very, very complicated because leaseholds have been around for 1,000 years. And my best guess, and it is a guess, I could be wrong, would be that once they looked into the detail of it and they realised how much money, some people suggest that the Treasury got involved and said, well, no, you can't do this with ground rents because it's going to result in huge compensation having to be paid to landlords. They thought, okay, well, we'll just make the bare bones of the Act and then we'll deal with the rest later. Now, some might form the view that the Tories thought, well, we never have to deal with this because we may not be in power after the election. So to answer the question, it's not been brought into force. There's a provision in the Act to cap ground rents at a peppercorn. How they're going to do it is beyond me. Whether they actually will do it is, to me, it seems doubtful. It would be a very hard thing to do as far as I understand it.
Someone, this is a little bit vague, but they've just said, I think in regards to estate management, do certified accounts need to be issued?
Without looking at that, yes, I think the whole point of the certified accounts, yeah, I think in respect of the, if I didn't flag it up in the bit, so I think what I said, that it's a new requirement for statements of accounts. It's in section 56. I won't bring it up on my screen because I'll probably show you all the confidential information on my screen. But I think if you look at section 56 of the Act, I imagine that not only do you have to produce the accounts, but I imagine they have to be served as well. I wouldn't be surprised if the detail is in regulations, but yeah, I suspect they will need to be provided to tenants as well.
Okay. Probably got time for one more or so. Someone's asked who will be creating the template for the service charge budget.
Now, I don't think anything I've suggested, I don't think I've said so far covers budgets. So I'm not sure where that question is coming from, but I don't think, unless I've misunderstood, that anything in the new act covers budgets. So I imagine the budgets will continue to be done by who's ever doing them at the moment. As I understand it, I don't think budgets are covered by the new legislation anyway, so it's no change to who currently does them, I think.
We'll try and squeeze in one more, I think. I think someone else said they mean the service charge demand for payment template is what that other question was referring to.
Oh, right. So usually with these things, these are drafted by government. And again, what usually happens in this case, there's the vague, well, it's not vague, it's, they say that this will be covered off in regulations. You know, what that means is up for debate. So it's usually the relevant government department will usually they issue a consultation on these things. So they usually say something like, we propose this, what are your views? And people can have their say. And eventually they will come up with a prescribed form of demand, which will find its way into regulations, which we then all have to use.
Okay, we'll fit in this last one from Catherine. She's asked, where ground rent is payable within an RMC wishing to use it for reserve funds and major works, does this legislation make that impossible, rather?
Oh, sorry, RMT.
RMC, yeah, wishing to use the ground rent for reserve funds and major works.
Sorry, could you ask that question? I got slightly thrown by the fact we're talking about ground rent and service charge.
No, yes, so she said where ground rent is payable within an RMC wishing to use it for reserve funds and major works, does this legislation make that impossible?
I don't think so, because if you're entitled to ground rent, then I think it would be, yeah, I can see why if you're a resident-owned company that you might want to put that money towards the service charges. But no, I can't see that would, to me, that's like a voluntary payment, isn't it? Because ground rent has nothing to do with service charges. So if you as a company decide to put all your ground rent towards the service charge, I can't see why that would be prohibited, because that's something you're volunteering to do. It's not really, that's not so much about a provision about service charges, it's what you're volunteering to do with ground rent. So no, I can't see that that would be a problem if that's something that you chose to do.
Okay, no problem. Okay, we've only got a minute left, so I think we'll finish up there. If we haven't managed to get through your questions, then please feel free to get in touch with me or Jonathan, and we will try and get back to you outside of the webinar. The presentation will be supplied, so I'll be able to send out a PDF copy of that this afternoon with the recording of today's webinar. And yes, thank you very much for joining us. Thank you, Jonathan, for your time this morning, and I will see you on the next webinar. Have a good day, Jonathan.
Thanks very much. Bye, everyone. Thank you.
Bye.